The ACLJ front and center right involved in this. And of course, the breaking news is the appeals court has thrown out the massive nearly $500 million penalty against President Trump.
So this is the case that was before Judge Engeron, which, remember, the famous photo op that people made an Office meme out of because it was ridiculous. He allowed cameras in his courtroom to come take photos. And then he handed down, there was no jury, this was a bench trial, where he handed down a $400 million judgment, but with penalties and interest, puts it over $500 million penalty against President Trump. It also banned him and his family from running the business of the Trump organization. And this was Letitia James' civil fraud case. This was the case where she said that Mar-a-Lago and other assets were overvalued and able to get loans, and then that enriched the Trump organization. The Supreme Court, which is what the lowest court in New York is, handed down this huge penalty, unprecedented penalty against President Trump. Well, today, in an appeal at the New York Supreme Court Appellate Division, First Judicial Department, a 5-judge panel handed down an opinion which completely wipes out that $500 million penalty. They said it violated the 8th Amendment of the United States Constitution. And right there, you see the opinion on the front page, who is listed as a party to it, because we filed in this case, making an argument that it's the American Center for Law and Justice.
It's very significant because it was clearly an excessive fine. It violated the 8th Amendment. The ACLJ played a pivotal role here. We wrote a brief that argued that allowing that judgment to stand, that Letitia James brought this suit, would in fact violate the Constitution, would also inhibit free speech and political discourse. And what is, I think, very significant here is Judge Friedman, in his opinion, writes that it not just references our brief, but quotes our brief. We said the statute provides a license for the Attorney General to pursue anyone based on an alleged inaccuracy and regardless of whether anyone has been harmed, just as she did here. And then it said, by removing the inherent protections of traditional fraud law, Section 63 enables political opponents to be prosecuted under a regime of strict liability, regardless of any actual culpability or mental state. The mental state is intent to commit a civil fraud. So Judge Friedman cites our brief in the case, and I want to underscore the importance of this. When we talk about an amicus brief, some people say, well, what is that exactly? It's amicus stands for friend of the court. We had standing to file a brief in the case as a friend of the court, and our briefs as amicus briefs have been cited not only by appellate courts and federal appellate courts and state appellate courts, but we've been cited by the U.S. Supreme Court as an amicus. So this is a huge win. But the deterrent effect of political activity and investment in New York City, a lot of businesses left New York because of their concerns about what happened to President Trump. And these are not necessarily people that had any political axe to grind. It was just they were concerned about doing business in a state where they could do something like this. Now, there's going to be an appeal here to the next level. This was the appellate division, which is the intermediate appellate court. It will now go to the Court of Appeals. And I will assure everyone that's listening right now that the American Center for Law and Justice is going to be front and center. We spent a lot of time on this brief and to work it out. And the reality is this is a big win, but we need the next step here, which is 2 of the justices would have voted to dismiss the entire matter. And I think at the appeals court, at the next level, we're going to win that aspect too. But those fines are gone.
Knowing already that there are some of these justices in the appellate division that think that the entire charge should have been dismissed, and knowing that our rationale was used by one of those justices on this appellate division, does that give one more, gumption behind our fight as we take this forward, that it could be total vindication by even having this completely wiped from the books?
We have a real chance at that. I mean, I'm optimistic. I mean, first of all, getting those civil penalties, which were draconian to say the least, out of the way is a huge win. The next phase will be this injunction that they put in place, which puts some restrictions on how the Trump organization does business. We've been involved in these cases from the outset, but I want to underscore something here Logan, that you said, you look at the work of the American Center for Law and Justice. We're talking about 35 years of victory. Here's one where we're defending the Constitution of the United States and the President of the United States, and we are successful. And the reality is, what's at stake is the ability of American citizens to do business, to engage in free speech without this kind of retaliation. And the fact that our brief got cited is huge.
I'm going to read one portion of this justice in his concurring in part and dissenting in part, really taking up, he later quotes us directly from our brief, but really taking up the argument that this was political lawfare against the president, something we had been saying the whole time. And he says, this action essentially turns Section 6312 on its head. The leniency with which the courts have construed the requirement for pleading and proving fraud under Section 63, a leniency that has extended for the purpose of facilitating the use under provision to prevent the exploitation of unsophisticated customers, investors, and small businesses, is here being used by Attorney General Letitia James to apply Section 63 to a scenario to which the provision has never before been applied or even thought to apply. So he's saying the Attorney General being able to bring these actions in this case is meant for a specific purpose. It's meant to be to stop people from being exploited by businesses, banks, whatever, on unsophisticated customers, consumers, investors, etc. They don't have the resources. They're not savvy enough to understand the complexities of a fraud that's being brought upon them. Then he goes further and says the Attorney General in this case has utilized the flexibility afforded to her under this section to unwind complex financial transactions that were negotiated face-to-face and at arm's length between a privately held real estate organization and ultra-sophisticated banks, insurance companies, government entities, which were well advised by equally sophisticated lawyers, accountants, and other business professionals. If essentially
who never
saying
issued a complaint,
right.
Who never had a problem with any of this. This was all made up. They've said that the president and his organizations never missed a payment, never had any issues with the financial side of this. If there was a crime that you would say is what do they call that? Like a meaningless crime, a harmless crime,
right? Victimless crime.
Victimless crime. This would be it. Which is a bank says yes, here's a loan. And they repay that loan successfully.
Right. They keep saying that the Trump organization, enriched themselves by this fraud. You know who else made a lot of money off that? The banks that did business with him. There wasn't a true victim. They were trying to restore the public trust, et cetera, through using this. However, this judge, and I think that's once again where your dad was talking about, it bodes well for the future of this case because getting this entirely wiped free. We know the reason she did this. It was a politically motivated attack on the president. And he lays it out there. We laid it out there in our brief. And also the majority of this court agreed that this is absurd what they handed down against him. Over $500 million, unprecedented. The way this law was used was unprecedented. All of it shows what we said from the beginning. It was lawfare to try and take down President Trump. It was not trying to do something for the goodwill of the state of New York under this attorney general.